Thank you so much, Kelly. Let me just get started with sharing our presentation for you guys. All right, so as Kelly mentioned, Furman and I are with the Community Economic Development Clinic at Albany Law School. The clinic is housed in the Albany Law School's Justice Center, which is essentially an in-house clinic for students to get involved in legal work. Specifically, the clinic, the Community Economic Development Clinic, which I will be calling the CEDC, just to have you familiar with some of our acronyms, allows students to learn corporate law and deal closing skills, including client counseling, interviewing, negotiations, and public speaking. And this presentation is interactive. So I'm going to give everyone about 30 seconds to a minute just to join with your phone. This is a QR code that will allow you to participate in our presentation today. And if anybody has any issues, just write in the chat and I will do my best to help. And Nancy also included the link in the chat. So thank you, Nancy. I appreciate that. All right, so we're going to jump into our presentation here and introduce ourselves. My name is Jordan Conway, and I'm actually not an attorney quite yet. I'm a 3L student at Albany Law School, and my role in the clinic is a pro bono scholar, which is essentially a program through the New York State courts that allows me to spend my final semester of law school doing roughly 500 hours of pro bono work, and I chose to do it with the CEDC. After graduation, I will be joining Whiteman, Osterman, and Hanna in downtown Albany as an associate. And this is my supervising attorney and mentor, Furman Mendez, and I will allow him to introduce himself.
Hello. So not to sell Jordan short at all, Pro Bono Scholars is reserved, the program is reserved for only our most stellar students. And so she should give herself a little bit more credit. But she's phenomenal and is doing great work for the clinic. My name is Fedmin Mendez. I am a director of the Community Economic Development Clinic. I have been a practicing attorney for nearly over a decade. My background is in venture capital and mergers and acquisitions and intellectual property. I've worked firms from here to from Michigan to here. I've owned my own firm, and I've been in academia for the last 6 years, teaching at University of Michigan, running the Entrepreneurship Law Clinic, and then being here at Albany for the last 3. Love the work that I do. I've been a startup attorney for a long time, so I've probably seen most things, and I'm always open to new things.
Awesome. All right, so let's jump into our agenda for today. The first thing we're going to talk about is contractual considerations, things that you should think about when you're in an agreement with a client. Generally, your scope of work, what sort of terms you might want to include. Then we'll move into intellectual property. We'll give you some definitions of intellectual property, what types of intellectual property your entity might have. And then we'll move into confidentiality and how to protect that intellectual property, specifically with non-disclosure agreements. Why would you want to use a non-disclosure agreement, and how to protect your entity's intellectual property through a non-disclosure agreement. As you can see, I've used some more acronyms. There's a lot of those in law, so we're going to allow you to become familiar with them. IP meaning intellectual property, and NDA meaning non-disclosure agreements. Finally, we'll round out our presentation with some best practices in confidentiality and just general things that your startup might want to consider in protecting information. Obviously, we have a limited amount of time today, so I just threw in some best practices, things that you might want to consider either asking us at the end or looking up on your own time, or referring to your own legal counsel with. All right, so for contract considerations, the first thing that you will want to consider is the relationship that you're building with your client. Is it an independent contractor relationship? Is it an ongoing relationship? Is it an exclusive relationship? And really define what sort of relationship you are entering into. After that, you will want to consider the term of the contract, if it's going to be indefinite or if there's going to be some limiting factors. When considering intellectual property and IP, there may be a point where the intellectual property no longer has value, and therefore your agreement might be mute. Later, we'll talk about trade secrets and how the value of a trade secret can
Essentially change.
essentially change. You also want to consider and talk to your client about payment. How are they going to pay you for your services? Is it going to be upfront, installations, installments, a retainer agreement? Or are they going to pay you when the contract is satisfied and all the deliverables are met? Payment may be dependent on those deliverables that you are ensuring for your client. Lastly, the scope of work is a really important piece of your contract. You really want to understand what your client needs and what their goals are. It's important to ask yourself why your client is hiring you specifically to do the work and include that in your agreement with them. And finally, this is going to be a little legal, so if you have questions, feel free to ask. But is your contract the final integration of your agreement? And what I mean by that is if you had prior agreements with them, such as an MOU, a preliminary agreement, or a letter of intent, the final contract that you create with your client will generally supersede those agreements, and be the full agreement that will supersede all other contracts. In the legal world, we call this like a merger clause. And if you want to impress your friends later, it's under the parole evidence rule. So there's just a little bit of legal knowledge for you related to contracts. So next, we do have what is your read on changes for non-competes? We'll answer that at the end.
Yeah.
Okay. All right, moving into intellectual property. Generally, IP refers to the bundle of rights that you have, that's intangible. The US, so there's 4 different types of intellectual property generally. The first is the patent, which the US it's federal. The US government gives exclusive rights, which entitles an inventor to prevent anyone else from making, using, selling, or offering to sell that patented invention. One of my favorite movies that you might be familiar with is Flash of Genius, where Greg Kinnear plays this inventor and who develops the intermittent windshield wiper. And the inventor ends up bringing a lawsuit against Ford for infringing on the patent. So just a quick example of that type of patent. You might be also familiar with patents through shows like Shark Tank, where they constantly refer to the value of something in a startup because they have a patent. Another type of intellectual property I know you're familiar with these types of intellectual property, just maybe not the terms, is a trademark, which can be any word, phrase, name, symbol, sound, design that identifies and distinguishes a company's products from those made or sold by competition. The example I like to use for this one is the word Nike and its swoosh versus Adidas and its 3 stripes versus Under Armour and its UA, or Puma and its cougar. The logos and the names are trademarks. Moving on, we have trade secrets. So trade secrets are all forms and types of financial, business, scientific, technical, economic, or engineering information. This can include patterns, plans, compilations, programs, formulas, anything tangible or intangible. And the important thing to know about trade secrets is that the owner must take reasonable measures to keep that information secret. And this info derives its value from being something that is not generally known. In other words, it's not in the public domain. So a trade secret can be something even as simple as like a customer sales list, or another giant example that we like to use is the recipe for Coca-Cola. it's not generally known and it drives its value from being secret. Lastly, we have copyrights. This gives an owner of an original work authorship and essentially the exclusive right to obtain economic benefits from the work. This is typically seen in books, works of art, music recordings. The big example I like to use for this one, as a Swiftie myself, is the Taylor's version. Taylor Swift has been recreating all of her own music to have that exclusive right and economic benefit, whereas Scooter Braun had previously purchased her copyright. And that's been kind of ongoing in the media. And moving on. So here's an opportunity for you guys to interact with us. Now that you've gotten some definitions of intellectual property, we'd like to know what type of intellectual property does your entity have? So feel free to give us this is an active poll, so feel free to interact if you have your phones open and let us know. All right, so we've got trade secrets and copyright coming up right away. That's cool. I'll give it a couple minutes. Patents. All right, it looks like we have mostly trade secrets. So we'll keep going. Some considerations that you might want to have when considering intellectual property. First of all, are you creating intellectual property for your client? And if you are creating intellectual property for your client, who owns the intellectual property when you're completed with the transaction? Or if it's an ongoing transaction, how is that intellectual property going to be used? Will you retain any ownership to it? Secondly, are you going to be using your own intellectual property, the client's intellectual property, or the intellectual property of a third party? It's really important to consider who's going to have access to that intellectual property or is going to be engaging with it. You might not think about accountants, consultants, or other clients of your clients who will have access to that, and it's important to discern that in an agreement. Also, there's generally two types of NDA agreements, but I want to mention them now just to give you a little bit of background: unilateral or mutual. In a unilateral agreement, one party has the obligation not to disclose information. And essentially, just to give you an example, if I'm saying I'm providing you with confidential information and you have the obligation not to disclose it, compared to a mutual agreement where both parties are disclosing confidential information. In other words, there's a mutual obligation not to disclose. And I will discuss this further and provide some examples on the next slide of the type of terminology that we'll use. And lastly, how are you protecting intellectual property? As you saw on our agenda, we'll be discussing NDA agreements later on in this presentation. So when we're talking about mutual and unilateral agreements, you'll see that there's a little bit of difference in the terminology. And I pulled this terminology from some of our legal resources just to show you the difference. In a mutual agreement, there clearly states that either party may disclose. You can see that in the highlighted section on the left side. And on the right side is the language that might be used in a unilateral agreement where it says the disclosing party may disclose to recipient. So when you're creating an agreement or you're reviewing an agreement with a client, it's important to know the obligations of the parties. All right, so let's get into some non-disclosure agreements. A lot of you have probably heard the term a non-disclosure agreement and understand that it's a tool that is used to provide protection for confidential information that can be valuable to your business.
Pause super quick.
Sure.
Can we get a quick show of hands on Zoom? Just how many people have actually entered into an NDA before? Do you recall if it was mutual? Well, let me give a chance for people to respond. Got a few hands. Okay, great. Who actually recalls whether or not it was unilateral or mutual?
Chat is showing mutual, one unilateral.
And then things that we'll talk about that are also super important going forward is who knows if they're still under confidentiality obligations? Right, thanks. This is great feedback. All right,
Cool.
keep going, Jordan.
Thanks, everyone. All right. So another opportunity to interact with us is what kinds of information would you protect with an NDA? Some of you have already mentioned that you use an NDA. Just generally, this will create a word cloud for us if you enter it in on your phones of just what type of information you're generally protecting. Don't be too specific. We obviously don't want to infringe on your NDAs that you are currently signed. IP generally, algorithm, that's cool. Process. Patient info, MTA. I also have it in the chat. Design. Awesome. Thank you guys for sharing that with us. So let's move on to why would you want to use an NDA? Obviously, you guys have used an NDA before. Some of you have, so you understand that it's an important. The first thing about using an NDA is to avoid confusion. You really want both parties, including yourself, to consider what is confidential and what parties consider to be confidential. Going back, this also goes back to the mutual and unilateral different types of agreements where you want both parties to understand who has the obligation of keeping that information confidential. Is it both parties or is it just one party? Secondly, how should that confidential information, once it's identified, be treated? There should be expectations you have in your agreement regarding the treatment of that information between parties. Identifying the IP that is being protected is really important, and how you expect for it to be treated, especially with third parties, consultants, anyone else who might be involved in the transaction or in the future. Lastly, enforcement. It's great to have an NDA because it's a tool that you can use to enforce a confidentiality agreement, and it's easier to enforce than an oral agreement. However, enforcement does cost money and litigation can be expensive. So it's not an end all be all. But your NDA, you might want to consider including in your NDA some options for mediation or arbitration, or what we like to call alternative dispute resolution, where the first action isn't necessarily litigation. And you can even include, should the confidentiality agreement / NDA be breached, that the attorney fees are for litigation could be included. Okay, so this is a live quiz, and if you guys are on, the question that we're asking is, and I'm sure you can see it on your Slido, is when should you consider an NDA agreement? This is more of a multiple choice, and if you know the answer, great. If not,
That's fine too.
that's fine too. And if you have any issues, just let me know. Okay, people are entering their names. Maybe it's not working. Okay, so here's the quiz. Sorry, that took a
Technical
minute.
difficulties, okay.
Yeah. Or if you guys want to enter into the chat, if Slido isn't quite working, these are the three answers. When should my business consider an NDA? Is it at the outset of negotiations, during the transactional agreement, or after the transactional agreement? Okay, I have someone in the chat who says at the onset. Onset. All right, we see it during the transactional. Great. So 80% of you guys said at the outset of negotiations. That's exactly what we would advise. And oh, good job.
Good job, Nancy.
Good job, Nancy. So basically how to use an NDA. Why would you want to use an NDA at the outset of negotiations? Well, the answer to that is because you're going to have information during negotiations that might be used, confidential information, while you're entering the transaction. And you don't want to have that confidential information during the negotiations end up becoming disclosable. A lot of you guys mentioned that you have trade secrets. Well, if you're discussing certain trade secrets that you have and the sole value of the trade secret is dependent on it not being publicly disclosed, you want to make sure it's protected during the negotiations. So
If you recall as well, Jordan had said that part of protecting a trade secret is having a security scheme in place where you're either frequently using NDAs, marking documents as confidential, when you're orally delivering information, being redundant and saying this is confidential information. Because at all markers, you want to have your act together in terms of saying this is all confidential information. Because the moment you start to not act like it, the party can become confused. And trade secrets, it doesn't really matter whether or not you have an agreement. If someone discloses it, it's no longer a trade secret. You have an action against them, but you no longer have a trade secret.
thanks, Furman.
No problem.
So moving on, you might have a freestanding agreement and a clause within a transaction to compose your NDA. And the reason I'm saying that you could have both is because if you're entering negotiations, you could have a freestanding agreement at the beginning of negotiations. And at the end, when you have a final agreement, you might have a clause within a transaction. And I'm just going to refer you back to our contract consideration slide where we noted that the final contract will generally supersede any previous contracts. So that's really important to think about if you're going to be using an NDA where there's a clause within a transaction for a final agreement. Okay. Lastly, we have, as I mentioned in our agenda, we're going to go through some best practices. Just because we have such a limited amount of time today, but we also just want to make sure that we address as much as we can. The first thing I would implore you guys to think about is, does your business have a confidentiality policy? What processes does your entity have in place to make sure that your IP is protected during client transactions? It might be a lot easier for you to generate and incorporate an NDA agreement into a transaction if your company has already identified the types of information that needs to be protected, and how that process works in your general transacting. Secondly, receiving and sharing confidential information from other entities. You always want to consider where that information in IP could end up, considering third parties, consultants, accountants, anyone who might be engaging with that, and whether what obligations you might have considering the mutual or versus unilateral aspect of those agreements. Moving on, how long should your NDA be and how long do your confidential obligations last? You might want to remember, just going back, a lot of you mentioned that you do have trade secrets. Is there a point at which that information is no longer valuable, and what reasonable steps are you taking to ensure that it doesn't enter the public domain? And lastly, some of you guys did mention that you had patents. There are liabilities that could be incurred from state and federal law. As I mentioned previously in my IP slide, patents are a federally protected and a right given by the federal government. So there are laws in place to protect patent infringement. So when you're considering confidentiality and infringement, you also want to consider the state and federal laws that are also protecting those rights. And you might want to reach out to legal counsel if you have it. Or if you're a startup, maybe come see us at the CDC and we can help you out. So that brings us to the close of our presentation. And I know that we already have some questions in the chat. So I'm going to turn it over to Furman to help us to answer some of these. Our first question is, on customer lists, you can own the list, but not ownership of the customer, correct?
So with that, it comes down to, all right, you can't own the customer, but what lots of instances, when you enter into a transaction with someone or you have an employee, rather than a non-compete clause, you'll see a non-solicitation clause. The non-solicitation clause usually covers the, hey, you person that I'm doing business with, you can't try to poach my employees, so not technically a non-compete, and you can't poach my customers, also not a non-compete. So it's one way to protect if you're sharing trade secrets with someone, part of my trade secret is my customer list, but also there's this extra obligation, like you can't steal my customers. And it usually has some time period attached to it. So it's like while we're doing business together and usually 1 to 2 years after. It all depends on what you negotiate. But lots of super restrictive clauses like that tend to be in the safe zone if you keep them about 1 to 2 years after the contract is up. But I've seen them go longer. Anything else on that question?
And I will watch the chat as well.
Okay. All right. So this is license access agreement for use of any IP sources for good agreements. Where's the question? All right, what can someone elaborate on that?
Whoever asked that question, feel free to come off mute.
Yeah, feel free to don't you don't have to use the chat. Feel free to just talk as well.
Yeah, so if our product line is going to be using an open strategy for allowing outside IP come in. Are there good examples or references for agreements that I can reference for establishing licensing agreements for use of IP in the products?
Well, it depends on what the source of information is. Are these open source information products? Like where's the IP?
So this would be say a researcher that has developed a patent for a process or a medical technique that's going to incorporate into our product as a teaching device. And so now they would maintain ownership of the IP in the form of the patent, but we would have the ability to license the use of that technology or procedure in our equipment, but do it as, so we would have exclusive access to that or limited.
Yeah, that sounds like just a patent license agreement. And sometimes the titles extend to say patent and know-how license agreement because all the associated know-how with that patent, especially when it comes to a device. So there are some available. I would strongly suggest talking to counsel. I might seem biased as a lawyer, but I do think it's difficult to navigate that process by yourself. But rule of thumb is going to be that you need a patent and know-how license agreement.
All right. Is that something that the group up in Albany would be able to assist with as far as setting up initial parameters?
Yeah, potentially. I've done many a licensing agreement. So the thing about, actually would be really helpful. So about the CEDC is that we typically take on clients both in the fall and spring semesters. If you apply early in the semester, it's better than applying later. We can do some work over the course of the summer because I have some staff attorneys that assist with work over the summer. We might have an intern or two, but primarily you work with students and a supervising attorney during the semester. What I would recommend is checking out our website and applying through our web application. And then from there, anyone would reach out to conduct an intake interview, and we'll see if we have capacity. So
That would be through Albany law or through the
Albany
CDC?
law.
Okay,
Well, the CDC is part of Albany law. So
Okay.
what I would say is look up Albany law, CEDC web application, and it'll bring you to it.
okay.
So the next question we have here is, what is your read on changes for non-competes from FTC and New York State?
Yeah, don't use them. It's not great. This in New York seems like they won't honor them. The FTC is probably going to push for federal policy. Other than that, non-competes are basically a form of employment law. Employment law tends to be very state focused. Usually the state that's implicated is the state where the company is from. But oftentimes, there will be certain long arm type statutes, long arm meaning that the statute will literally reach across jurisdictions to protect the employees. So California is pretty guilty of this. I think Massachusetts, I'm trying to recall, I think they have some issue with non-competes as well. And New York is a new one. So honestly, I would really evaluate it. Now, the fact is non-competes are really dealing with how they impact employee-employer relationships, as opposed to if you buy a business from someone and say, hey, let's say I'm buying your pizzeria. You don't get to go, other side of town and open a pizzeria again. Those non-competes are still honored.
And Nancy has included the website for the Community Economic Development Clinic in the chat if anybody's interested in completing an intake application. Thank you, Nancy. Appreciate that.
No problem. Are there any other questions? Feel free to come off mute, or I'm sure you could contact Jordan and Fairman afterwards. But
I'm an open book, and we've got like another 10, 15 minutes. So you've got over a decade of startup legal experience. So please ask away.
May I speak?
Go for it.
Hi, my name is Sumanta Goswami. I run a clinical lab here, in fact, right next door to you guys.
Oh,
So,
awesome.
actually, I'm currently in the process of developing some MOUs with two large universities. One is Rutgers, and the other one is Albert Einstein College of Medicine. So essentially, there will be three components of this. One is a material transfer agreement. One is non-confidentiality. Another is future IP. Okay, so honestly, as a startup, you can imagine my finances are very tight. So I really would like to know if there is some kind of help that I can get from you guys in terms of some boilerplate, like MOU plan, like templates that you can offer, which I can work with the respective universities. And once they have given me their input, I can then come to you guys with minimal, expenditure, get those things, signed off.
Well, so the thing to keep in mind for us is that we're free. I guess we didn't emphasize that. The CDC provides free legal services.
I love free.
Doesn't everyone? But again, we might be a little time restricted. What I would also say is that even if you were to get templates, you're dealing with several universities, and they all have what's called a tech transfer office. And those tech transfer offices are going to hit you with their own agreements.
I know.
So you might not even have the ability to really put in your own agreement. You might negotiate it from there.
Right.
I can point you in the direction of some information primers to potentially get up to some stuff. I tend personally not to give out boilerplate agreements for these sorts of things, just because they can be so complicated and they're really personalized. I don't want to ever give someone a boilerplate and send them into the lion's den. But I can give you some information.
You see, my problem why I'm requesting this is that
I totally get it.
I know exactly what you are saying. I
Yeah.
have done this kind of agreement with Wadsworth before, and the few lines that I sent were not only written over but cancelled and everything. But the question is, unfortunately, in both these cases, both for Rutgers and for Montefiore Medical Center, I am right now interacting with the scientists, and they're asking me to give something to them, which they can now take to their tech transfer office.
And here's the thing, their tech transfer office, honestly, they need to start the conversation with their tech transfer office because, you know, to the extent they're creating intellectual property, there's usually disclosure, like literally disclosure forms that they have to fill out on a regular basis, which goes from their lab up through the university into the tech transfer office.
Right.
And so it should all really start and stop with tech transfer. If you need some assistance, you can apply to the clinic so we can help on your end. But honestly, once you guys start moving to that degree, it's going to be a tech transfer office because every single university as well has a very strict intellectual property policy. For students, it's pretty easygoing. Students, hey, you get to keep your IP. If you're an employee or a professor or just basically an employee, they own your intellectual property. And so you might not, it's out of their control. If there were students involved, students that create intellectual property have the ability to then give the university rights to their IP. And as part of that exchange, the university says, okay, well, we'll file any patents that are necessary for it. And then you get the first bite at having a license. So feel free to apply. Feel free to also email me. We could potentially talk further, but tech transfer is going to drive a lot of this.
Yeah, I understand that, but you see, like I said, basically what these professors are telling me, and I mean, I've also done this before from that side.
Yeah.
I was a professor at Einstein. So basically what they're telling me is that we have now prepared a scope of work PowerPoint, right? That what we think we will do, what are the resources that will come from the university, what resources will come from Albany Labs and things like that. So we've prepared a scope of work, this thing. And what they're saying is if from my side, if I have some like requests that, you know, this is not like this is to be protected, this is to be protected, we want X percentage. It's a sort of something to start negotiation. Then they will take it to their tech office, and tech office will work on that, maybe cancel everything that we say and write their own rules because they are big universities.
So how about we do this? Submit an application. In the next few weeks, I'll set up some time to talk to you because the other thing, a few things. One, this is going to require a little bit more time between the two of us. Two, I don't necessarily want you giving out your confidential information or being like technically what you're disclosing is confidential to some degree. So I want you to, this recording is going to go out. We might have to cut part of the recording. So
Right.
I want to be mindful of that. And then third, because this isn't quite yet an attorney-client relationship of any kind, I want to have some limited representation, actually take you through in a very initial stage of doing an intake conversation, so we can probably see a little bit more where you're at. Okay, so please feel free to apply. And anyone, I encourage you that if you have a problem or if you're interested, please apply. My background, like I said, VC, M&A, primarily related to tech.
Okay. Excellent. Thank you.
No problem.
Looks like we have a question from Kelly. Could you discuss Section 174 of the Jobs Act and how it will impact startups with federal R&D grants?
So despite the fact that I'm a relative expert at the Jobs Act, it's not that section. Much of my work deals with the crowdfunding aspect of the Jobs Act through regulation crowdfunding and then through regulation A+, and then accredited investor crowdfunding. But Kelly, if you describe a little bit of 174, I can probably opine on it.
There was some concern that the section was going to impact the amount of revenues that were going to need to be reported in a year because of the way the section was requiring startups to amortize the R&D expenses over 5 years as opposed to 1 year.
Yeah, I mean, the unfortunate thing with the federal government is it's constantly, unless you are the new hot topic, it's constantly minimizing the amount of federal grants it's willing to give, which is just an unfortunate thing generally. I fear if you are required to amortize over 5 instead of 1. They just expect you to take more of the cost impacts and might not give as much money. But why don't I'll do some looking up on that, and I'll give you a better, more informed answer.
That would be great. Thank you. It's
Oh.
definitely going to impede some innovation in our country if the companies are having to pay taxes on the grant funding that they're getting.
Yeah, no, absolutely.
Does anyone else have any other questions for us?
On the issue of startups and funding, one of the areas obviously is as you have potential investors coming in is getting agreements structured. Obviously, from the developing side of the equation, we're trying to give away as little equity as possible. From the people investing, they want to maximize the equity. But once you get past that point of negotiation, is structuring things for, say, a second or a third round of funding and how things mature from that. So you don't have over dilution of either party in that, and making sure at the early rounds everybody's protected. But to use the model of what happened in the with Facebook, which is, certain parties get overly diluted to the advantages of others, is making sure that that comes into play. Is that something within the wheelhouse of what the CDC would be able to support as far as structuring?
So I've helped structure many a financing round. What I would say is, as much as people want to try to have the Facebook model, honestly, that's going to be impediment to you getting funding in the first place.
Yeah,
Now,
no, I'm not looking at
Yeah.
using the Facebook.
Yeah.
I'm pointing as a problem
Yeah.
of when the agreements are written up to favor one side or the other.
Absolutely. So I've taken companies through multiple rounds of financing. Primarily my advice to founders is, if you're a founder, every time you're going to get diluted. So as you get diluted, the thing to request to each of your investors, or to your lead investor or your board, is, hey, if I'm going to stick around, I would not like to get overly diluted. I would like an additional grant of options. And that's sort of the incentive package for you to stay. So you can always top yourself off a little bit, and lessen the impact of dilution. When it comes to your investors, the initial investors are going to have a few things that are going to protect them. One, what sort of anti-dilution adjustments do they get? So if you have a down round meaning even though the value of your company might go up, if the stock price literally is less than the last round that it was offered for, there's a price-based adjustment where your prior investors' investment amount will count for more than it did before. Going forward from there, there's something called pro rata rights. Pro rata rights is something usually reserved for your big money investors, usually your lead and someone who's gone past a certain arbitrary investment amount, but usually, you want it to be pretty significant. And so what that says is that you have the right and privilege that if we go to raise more money, you can put more money down. We have to go to you first before we can sell out the rest of the round. It's not available to everyone. We try to keep that pretty limited. But as I explained it to another investor in another company the other day, I was like, yeah, it's kind of anti-dilution protection, but you kind of have to pay more money. So not really.
Yeah.
Investors understand that.
Yeah.
Just gonna do we have any other questions that people want to ask? I think we have about 10 minutes left.
See any more on my end?
All right. Well, if that's all, you guys have our website. You have this recording, but we might need to doctor it up a little bit. Feel free to apply. Otherwise, feel free to email me if you want to chat. We're rounding out the end of the semester, so it might take a little bit more time for me to get to you, but I will get to you. I also have a newborn daughter at home, so again, might be a little difficult to get to you, but guarantee someone will get back. I will reach out to you. But yeah, we love working with Innovate 518. And we're looking forward to doing more of these in the future.
Thank you so much, Jordan and Fairman. I'm gonna drop a couple of things in the link, and when you leave the Zoom, a little survey will pop up. So if you have a second, if you can answer that survey for us. The first thing I'm gonna drop is just a link to the Innovate 518 website where you can see all the events that are coming up in the region. So definitely check that out. And I will one more time drop the link for the clinic. Definitely check that out. And then finally, sign up for our mailing list if you found out about this event through some other place besides our newsletter. Okay, and I think that's gonna be it. Thank you so much for your time today. And we will be following up with an email with all the resources and the links that were shared today. All right, thank you, everyone.
Thanks,
All right,
Nancy.
thank you,
Thanks,
guys.
everyone.
Bye.